Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Special guest, the co-host, Jesse Barrientos. It's going to be all about you today, Jesse. Welcome to the show.
Fantastic. Thank you, Dave.
A little background information, Jesse. You graduated from the Loyola University in 1987.
That's correct, with a double major in communication and philosophy, cum laude.
Okay, and then you moved on to the John Marshall Law School, and you graduated there in November of 1991.
That's correct.
And then from there, you became a member of the bar, and you're a part of the DuPage County Bar Association as well as the Will County Bar Association, correct?
That's correct.
Okay, and the focus of your practice for the most part, and we're going to talk about that today, is divorce and family law.
That's correct.
Okay, there's so many different issues that fall into a divorce or family law case, anything from custody, support, visitation, division of assets, moving out of the jurisdiction with the child, paternity. When people are not married, you still have all those same issues. So let's get right into it. What do you most commonly see from clients who come to you for help? What are they most likely to be seeking when they're phoning you?
A lot of people have issues when it comes down to children with one spouse or a mother withholding visitation because they're not receiving any type of support because nothing has been filed. A lot of times it'll be somebody will take empty out a bank account, and not a small amount. We had one where it's $150,000. It's there one day and all of a sudden, boom, it's gone, and so have to rush right into court to get an emergency temporary restraining order just so that the money can get frozen until all of the rights of the parties get taken care of. But most of the time, it really does come down to visitation and custody.
Okay, let's talk about practicing in the multiple jurisdictions that you do, from Cook to DuPage, over to Will, a little bit of Kane, even Lake on occasion.
And Kendall?
And Kendall. What are some of the differences that you have to be aware of as a practitioner when you're going through the different counties?
Different judges, not only in different counties, but also with just different judges have their own proclivities. They want things done a certain way, and you better pretty much do them the way that they want you to do them. Different counties have different procedures for example, doing a prove-up. A prove-up is what we call, finalizing the divorce. Everything's signed, you have an agreement, and now you just have to put on the proofs to establish what you've alleged in the petition for dissolution of marriage so that the divorce can become final. Things with scheduling, just for example, in Kendall County, in order to even schedule a prove-up, you have to have all of the original prove-up documents submitted to the clerk in order for them to even just schedule that prove-up. Is it the best system? I mean, I don't know, but it makes sense because you don't have to worry about it. Other jurisdictions, there's no need to do that. You just set in a draft order that it's going to be set for prove-up, and most likely it will go. Sometimes it won't. Sometimes there are complications.
Yeah. Now, a few years back, you co-wrote the book Divorce and Family Law. Who has the legal right when things go terribly wrong? What was your thought behind co-writing this book for people?
Well, the whole idea, and it's not meant to be certainly a legal treatise, is just to give regular folks a no-nonsense idea on the procedure and the process and what's kind of going on. This is one of these scary things in somebody's life. The loss of a loved one, moving, a new job, moving to another state. Dissolution really is a death. It's a death of a relationship. And so it's important for people to be able to really comprehend, to really understand and take the time necessary to be able to do things right, because it's a major decision in someone's life. I have people sometimes where they just want to get things done. They don't care about it, and they're just antsy, and they want to make haste. There's a time to make haste, but this isn't the time. You want to make sure that you cover everything. You want to make sure, because divorce is about dividing up the marital estate. When two people come together, it's come into one estate. So whatever people acquire during the course of the marriage generally is marital property. Whatever debts that people acquire during the course of the marriage is generally marital debt. And the only effective way, really the only way to be able to divide things up equitably is to know exactly what those things are. And if I don't know what those things are, you don't give me that information and we don't get it from the other party, how are we supposed to know what we're doing? I've seen judges, I think the last time was probably in Will County, where a couple parties went up for the prove-up that we were talking about, and they were going through everything, and they were going to the pension, and I think one of the spouses was waiving the pension, and there was probably a lot of money in there, and the judge was inquiring a little bit about what was in the pension. Well, do you know how much is in there? Well, no, and the judge didn't allow the prove-up to proceed because he wanted to make sure that that other party that was going to waive it knew exactly what was in there. It could have been a couple $100,000, who knows?
Even if the person said, I don't care what's in there, whether there's $2 or $2 million, I'm waiving my rights to it, the judge still wanted to make sure it wasn't unconscionable?
That's exactly right. The judge wanted to make sure that they knew, first of all, and then I suppose it would be a different matter if after he had knowledge of what was in there, he decided not to do that. Now the court, the judge is the one that's putting his or her name on that judgment in terms of signing off on it. And it's the court's responsibility to make sure that that agreement is, as you said, not unconscionable. What does unconscionable mean in real language? Make sure that it's fair, that it's not so slanted and so skewed as to kind of offend the sensibilities of a reasonable person.
Right. One of the good things about the book that you co-wrote is it's broken down into custody, support, visitation, whereby it provides the law in a very succinct paragraph, and then it talks about kind of all the ins and outs about it, but not in a lengthy process. So someone could go pinpoint exactly what they're seeking, what their issue is, whether it's custody, support, removal, visitation, alienation of affections, and get a general background. And I think that helps, does it not, with having an educated client, because then they're more familiar with what's going to be happening in the process?
It is, if they've kind of looked at it before they come to see me, but even if they haven't, that's okay. I really believe in information, kind of an informed consent type of situation. I want my clients or prospective clients to know exactly what the deal is on whatever issue it might be. A lot of attorneys sometimes, unfortunately, don't explain these type of things to their clients or potential clients in great detail. And part of my job, I believe, is to educate you because, again, as I said earlier, this is a major portion, major deal in your life. And I want you to know about everything. And a lot of times people will ask the same questions again, and, well, that's okay. I just want to make sure there's no misunderstanding, that they know exactly what I'm educating them about. I don't have a crystal ball, so I can't tell them what's going to happen. What I can tell them is what is likely to happen, what the various scenarios are. And it also really depends upon, again, what jurisdiction, and depending upon which jurisdiction you're in, which judge that you have, because again, certain judges have different proclivities toward different types of things, and that's why you want somebody who practices in those specific counties and knows those judges, because they have an idea on how the judge would react to a specific kind of an issue. And so that's certainly better for you.
Right. Now, many couples are not looking for a knockdown, drag-out fight, and they want to sometimes mediate their divorce, which is often a confusing situation. I know you are a mediator licensed in the state of Illinois or in the county. Can you talk about your capacity in that regard and what role you play in mediating a divorce?
Sure. A mediator doesn't necessarily have to be an attorney. I'm an attorney, and it's specific training that attorneys or other people receive to be able to do the mediation. And basically, there's two kinds of mediation. There's court-appointed or court-ordered mediation, and then there's private mediation. When it's court-ordered, they only do it for two issues. It's either custody or visitation. Really no financial issues, although sometimes I've mediated situations where some of the financial issues are so closely tied to the agreement, and I let the parties' attorneys know, and so they have an idea. Basically, a mediator is in control of the process, and the parties are in control of the outcome. It's the mediator's job to try to help these people reach their own agreement, rather than to have a judge who is going to listen to a thumbnail sketch of their life make a decision about their life that neither party is really going to like so much. One party may like it more than the other, but neither party really is going to like. And it's the mediator's job sometimes to find the underlying issues that afflict people. For example, I've had a couple of situations where a wife didn't want the husband to have overnight visitation. And so we ask about this and we delve into it a little bit. And the reason is because the person had ties to another place, Mexico, for example, and had family there and was worried that, okay, well, the husband could take the kids to Mexico. Well, my thought to her was, well, okay, but you're okay with him to have visitation all during the day, all day, but just not overnight. Right, okay. Well, why couldn't he take them to Mexico during the day?
Right.
So basically, that really wasn't the reason she didn't want him to have visitation overnight. It was more of a kind of a punishing thing. And I've been blessed so much in terms of people, the mediations, a lot of them have turned out successful. And that's what I really end up spending more time on mediations than they really give us. In DuPage, you really get 3 hours and then 1 hour for administrative. I always put more time into it. And if I can help the people come to a resolution, that's what I want to do. Now, on the other hand, there is private mediation where you can mediate any type of issue. And basically, you're trying to save the people all this time and money for litigation. And if you do mediate privately or court-appointed, you really can't represent either one of the other parties in the divorce when they file it. You're, again, just helping them come to that agreement. And once they reach the agreement, you could draft the agreement, but you certainly can't go to court into your appearance and represent either one. But a lot of people or a lot of attorneys will tell, unfortunately, their clients, oh, you don't have to agree in mediation, which is true, you don't have to. But if people don't come into the mediation with the expectation and the hope and the belief that they're going to be able to come to a resolution, then there's no point in really having the mediation and wasting everybody's time.
So you're helping to facilitate a resolution by giving them some parameters on what the court would likely do, what the ranges are for division of property and or child support. Is that among what you do?
Exactly. And again, when we're talking about financial issues, that would be outside of the court-appointed or court-ordered mediation.
Okay.
Yeah.
Well, to start a dissolution action in the state of Illinois, you have to have a reason. So if things are going well, obviously you don't have the ability or the right. So we're talking about grounds here.
Right.
You have to have grounds to start a dissolution action. Let's talk about some of the most common grounds and what they mean.
Well, there's mental and physical cruelty. There is...
mental cruelty, let's start with that.
Okay.
That's kind of a vague term. What is mental cruelty and how is it determined?
It is vague, and I think that it's rather easy to prove. Obviously, physical cruelty, I think, speaks for itself. If somebody has battered somebody, has been abusive, certainly that's establishable, and we could have testimony on that.
What about a 50 Shades of Grey deal? Is that physical cruelty? Or is that not what you mean?
Well, I don't know. I mean, I suppose it could be. It depends on the specific situation.
No, I'm kidding. We're talking about
right.
someone who's battering someone and physically abusing them and harming them and hurting them.
And so...
Against their will.
Against their will. When you're looking at mental cruelty, it could be as something as someone not appreciating the efforts that you're putting in to maintaining the household, into cooking, cleaning, raising the kids. It could be that somebody belittles the spouse and just doesn't pay much respect or attention to them and constantly harps and harasses that individual.
The problem is it appears and sounds like a personal attack when someone puts in the documents under oath that the other spouse was mentally cruel.
Right. Well, I actually get that a lot when the other side or my client comes and says, oh, saying all these things about me, or somebody comes to me and they've been served and says, saying I've been doing all this. The fact of the matter is, as you said, that you need grounds for filing any type of dissolution of marriage action. And there is, because Illinois is a no-fault state, a no-fault ground, which is irreconcilable differences. It just means that the parties really can't get along. But there's a caveat. They have to have lived separate and apart for a continuous period in excess of 2 years. All of that, except for 6 months, can be waived. It doesn't necessarily mean living apart like the plain meaning of the word, because it's been construed to mean that, people sometimes, when they're still living in the same house for financial reasons, somebody will move to a guest room or somebody will move to the attic or to the basement, and that's where they're sleeping. Or even they're still sleeping in the same bed, but they're no longer intimate, and they're really not living like husband and wife anymore. They're just like roommates. And so the marriage is essentially dead. And so that's the kind of timeline that you look at. But what we always do when we file a petition, because unless it's an agreed and we know that ahead of time and we file everything together, what happens is that we put that mental and physical cruelty in the petition for dissolution of marriage, and then we put irreconcilable differences as an alternate way of pleading, because nobody, and most divorces end up settling most of the time. And nobody's going to admit, Dave, have you ever been mentally or physically cruel?
No.
Okay, and you wouldn't admit it, even if
Talk
you had
about
been.
another one that is rarely admitted
Well,
to.
let me finish the thought here. And so when you do that, okay, you save time, because usually, hey, irreconcilable differences, no problem. So you don't have to go back and waste the time or the money to amend the pleading.
Yeah. Let's talk about adultery.
Yep.
Many clients, I'm sure, want that in the documents because it's true. But what would you caution them with regard to that, proceeding solely on those grounds?
I tell them, first of all, it's a matter of proof, how you're really going to prove it. And secondly, the only reason why they want it in the document is because it's a public document and they're just really intentioned, to publish. When people come to me, we explore a few things. Number one, want to make sure, hey, listen, is the marriage dead? Is there any chance, any possibility for reconciliation? Because if there is, now is the time to explore it with your spouse. If you've already done that, or there's no way, or hey, listen, you don't want a divorce, but the other spouse does, okay, not a whole lot you can do about that. Okay, then we go on to the next phase. It doesn't matter. In fact, it wouldn't matter if your spouse had slept with other people openly. It just doesn't really have that kind of bearing on the distribution of marital assets. It may have something to do with visitation or custody, but may. Right. I mean, it just really depends on the specific circumstances. So it really doesn't matter. And my job is to resolve this in the best way possible for my client, also keeping in mind the best interest of the minor children, if there are any minor children. So do you want to try to resolve this the quickest, most expeditious, most cheap way we can, or do you want to inflame the other side and have a drag out kind of fight? I've told people who've come in and just really wanted to punish the other side, I've told them, hey, listen, you know what? This is what I'm about. I'm trying to settle it. And if that's what you're looking for, you've got the wrong guy, because I'm not interested in doing that. There's plenty of other people that will help you do that.
Right. Let's talk about division of property. Some couples have next to nothing to be divided.
Well, half of nothing, Dave, is still nothing.
Right. Other parties have plenty.
Right.
And I'm talking about multiple houses, retirement accounts, stocks, bonds, vehicles, vacation homes. How do you handle, or how does the court provide an equitable distribution on a division of marital property?
Well, there are a lot of factors that go into that. You have to look at the finances of each of the spouses. You have to look at the standard of living of the marriage, during that time, and you have to look at exactly what's out there. If the husband has a pension with $100,000 in it, and the wife has a pension with $98,000, and it's pretty much more of a wash. It's not worth doing what they call a qualified domestic relation order. It's going to cost more than that extra $2,000. So they're pretty much evenly keeled. No point in doing that. However, if the husband has $500,000 in his pension that was acquired during the course of the marriage, and the wife has nothing, well, hey, guess what? It's going to get divided. More than likely, it'll get split in half. And then you look at the other types of things, like if there are other assets, other houses. It's just a matter of finding out exactly. It's sort of like doing a table or a spreadsheet. Okay, this is what he has. This is what she has, right? Okay, because there might be situations where people have property or accounts in their own name, and that's okay. It doesn't mean that it's not marital. If it was acquired during the course of the marriage, generally it is marital. Okay, so it doesn't matter if the other spouse's name is not it.
Well, not an inheritance account that's kept separately.
Not inheritance.
That's
That's why I said generally, right. That would be an exception, or a gift. That'd be an exception to the rule. However, the court does take into consideration a person's non-marital property. For example, if, Dave, you had $5 million in non-marital property and your marital estate was $200,000, what do you think that your spouse might get?
A good portion of that marital
The
estate.
lion's share, you bet.
Right.
Okay. But it's all about dividing it and again, making it even. Now, if, for example, the husband, and I'm just using the husband, makes $500,000 a year, and the wife, makes, say $100,000. Okay, there's a great disparity, and we'll talk about maintenance in a minute. But that might be a reason, if the parties are not in agreement, for the court to deviate and award her maybe a little bit more of that marital property than the husband, because this way it kind of evens it out, because he's still going to be able to earn at that level and she's not. Now, when you talk about maintenance, formerly called alimony, they just revamped the statute in January of this year, January 2015. And my understanding is they're going to revamp it again. My understanding is that they're going to revamp the whole Illinois Marriage and Dissolution of Marriage Act and the Paternity Act too. So we'll see what that brings. But when they did the maintenance provision, everybody's in the same situation. Pretty much what they said is that first the court has to determine whether or not maintenance is appropriate. And they look at those similar things that we've talked about in terms of the duration of the marriage. They looked at what's standard of living during the course of the marriage, what they make it, all that stuff. And then they take the gross income of the payor. The payor is a person who pays an obligation of support. The payee is a person who receives an obligation of support. So in this case, we're talking about maintenance, spousal support. They take the gross income and multiply it by 30%. Then they take the gross income of the payee, multiply that by 20%, subtract the difference, and that is the maintenance. Now, it depends upon how many years the people have been married, and the statute has everything kind of set out between 1 to 5, 5 to 7 or 8, and it goes on from there. And after 20 years, then it's more of a permanent nature, although it's not really permanent, because if there's a change in circumstances, it could always be adjusted. However, that being said, even when you make those calculations, it can't be more than 40% of the payor's income.
Okay. They're really taking the autonomy away from the judges
They are.
in determining how much maintenance for how long and all the rest.
Exactly. They're doing just that formula. And I think there's probably a happy medium somewhere. I don't know that we've reached it, but because a lot of times that won't necessarily be fair. What happens if you have an older couple? And surprisingly, I get a lot of older folks that are divorcing. And so you have a situation where somebody's going to have to pay maintenance, permanent maintenance, but what? They're going to retire. They're going to retire in 2 years. So you have those issues to work out, and the judges are still dealing with that as well, because it's new for them too.
They would have to come back into court and revisit that if it's a
That's
situation
exactly
where someone loses their income or something
Right.
like
It
that.
wouldn't be automatic.
Okay. Let's talk about the most contentious, most litigated issue in a divorce case, and that's where there's minor children and custody is in dispute. There's a lot to talk about here, but in a brief nutshell, talk to me about custody.
Custody is one of those sensitive issues, and again, in mediation, we get a lot of that, where you have two people who, one person doesn't want the other person to have anything to do with the child, except they certainly want the support. Pretty much, children deserve to have both of their parents in their life. Now, of course, there are exceptions to every rule. Sometimes there are people that may be so horrible or may have certain addictions or things of that nature that it might not be appropriate to have visitation, or maybe it's more appropriate to have supervised visitation. But a child does better when both parents are in his life. And listen, that's your child. You created that child. You have an obligation, as far as I'm concerned, as far as the court is concerned. You have a moral obligation, too, to take care of that child. And there are various types of custody. There is joint custody and there's sole custody, and then there is kind of a little hybrid on that. Joint custody means that the non-custodial parent, the parent who doesn't have physical possession of the children most of the time, has a say-so in the upbringing of the child as it relates to education, as it relates to religion, and as it relates to medical decisions. The older the children are, the more that those issues are already taken care of. They're already going to church or doing something. They're already established in a school. As far as medical, obviously it doesn't mean if there's an emergency, certainly you could take care of the emergency at hand. What it does mean is elective type of things, like maybe orthodontia, or God forbid, maybe your child might be a special needs child and there's a need to consult experts in that area. And so the other non-custodial parent wants to have a say-so, and hey, listen, whether or not, what expert should we get, and should we get a second opinion, those kinds of things. Sole custody is the exact opposite. The non-custodial parent doesn't have a say-so in those things. It doesn't mean that you lose your rights. It just means that the other parent can make unilateral decisions concerning those three areas, and those three areas only. You still have visitation, parenting time. You still have access to records and everything else. So a lot of people mistake that. There is one hybrid, which is joint residential custody. It's the exception to the rule. Basically, both parents have almost 50% time with the child, but it has to be a special situation. The child has to be old enough, and the parties have to live pretty close in proximity, and they have to get around. That's true with any type of joint custody. If the parties cannot cooperate in order to achieve and to take care of the best interest of the child, then joint custody is not appropriate. Court can't order joint custody. What they will order if you go to a trial is sole custody. So one person will get sole, and
How is child support calculated?
child support depends upon how many children that you have, and child support is calculated based upon a person's net income, which is defined by the statute. They take out taxes, the appropriate amount of taxes. You can take out your medical insurance and even life insurance to some extent, as it affects the child, because more than likely you're going to have a policy for that child. Union dues can be taken out. Now, sometimes there are wage earners who are public employees, like school teachers, who don't pay Social Security, so they pay into a mandatory pension. So it just depends on what that is. And so once you determine what the net is, for one child it's 20%, and then two is 28, 3, 32, and there's a progression in that. And that comes out. And again, it's a right of the child. The parties can't waive it, but the parties can deviate. Remember, you were talking about all this property before. So let's just take an easier example where we have a house that's worth, has $100,000 of equity. Maybe one child, maybe 8 or 10 years old. Okay, and so you are going to let your spouse keep the equity in the house. And in consideration for that, right, we're going to deviate from what you would normally pay in child support. And that's going to be spelled out very specifically. And in fact, the judge has to, in an order, spell out, listen, what is the normal amount of child support that would have to been paid, the guidelines, and what's the reason for the deviation?
Okay, and judges are reluctant to deviate because they don't want that to become an avenue that a lot of attorneys try to pursue.
They are sometimes. I've heard people, when we're talking about like 50-50 time, I've heard judges go back and forth depending upon where you're at. Okay, well, okay, Dad, yeah, you want 50-50 time. Okay, I can go with that, but you're going to pay child support.
Take it from me, personal experience. Up in Lake County on a prove-up. Judge saw that there was a deviation in my judgment. She put me to the end of the call so that the courthouse or courtroom was cleared out before she took up this issue. And she later told me that was why she didn't want the rest of the council to see that she deviated. So pretty crazy there.
Yeah, well, but you got the prove-up done and it wasn't unconscionable.
Okay.
Yeah.
Just a minute left.
Sure.
Visitation, what's reasonable?
General visitation is every other weekend from Friday after school, or if there's no school, any other time, maybe noon, till Sunday, maybe 7 or 8:30, depending upon the age of the child, and maybe one day during the week for dinner. Also alternating holidays. However, the parents really have to be flexible, because sometimes their schedule is going to be different, and they need to be able to exchange. We're also going to have or summer vacation, and you're going to have winter break and Easter break and all those things, and they need to kind of be divided. That's a general, very, very general type of parenting time or visitation schedule.
Great information. Jesse Barrientos, thank you for joining me.
Thanks,
as
Dave.
always. We'll see you next time on
good.
Legal Action. Take care.